Let's start the hour with this question. Can the President of the United States take control of independent federal agencies, such as the Federal Trade Commission? This is what justices on the U.S. Supreme Court consider today. So the issue is before the court after the president's firing of former Federal Trade Commissioner Rebecca Slaughter. Slaughter argues Congress designed the Federal Trade Commission to be bipartisan in investigating corporate mergers and consumer fraud. The arguments in court already heating up this morning. Let's listen in.
Let's start with the key legal question now being considered. To what extent can a U.S. president exercise control over independent federal agencies such as the Federal Trade Commission? This issue has reached the U.S. Supreme Court following the president's decision to remove former FTC Commissioner Rebecca Slaughter. Slaughter and her legal team argue that Congress intentionally structured the FTC as an independent bipartisan body designed to investigate corporate mergers and consumer protection issues without direct political pressure. During oral arguments, justices explored whether expanding presidential authority over such agencies could alter the balance of power between branches of government. Some justices raised concerns that allowing broader removal authority could concentrate significant policymaking and enforcement influence within the executive branch. Others emphasized that the Constitution vests executive power in the presidency, suggesting oversight of agencies may fall within that authority. The exchange reflects a deeper constitutional debate over separation of powers rather than a predetermined outcome. From a broader perspective, legal analysts note that the court's relationship with presidential authority has been evolving. Earlier rulings in 2025 were widely viewed by observers as granting the administration substantial latitude in areas such as federal workforce management, budget implementation, and agency restructuring. However, more recent decisions and procedural rulings suggest the court is also willing to impose limits in certain contexts. For example, in disputes over congressionally appropriated foreign aid, lower courts required funds to be released, and the Supreme Court declined to intervene at the emergency stage, a move some legal commentators interpret as reinforcing congressional spending authority. In another case involving National Guard deployments, the court blocked a federal action that would have overridden state leadership, underscoring federalism considerations. Immigration enforcement policies have also faced judicial scrutiny. In one instance, the court paused removals conducted under an expansive interpretation of wartime authorities, indicating that due process considerations remain central even in national security contexts. These rulings, while procedural in nature, are being closely analyzed for signals about how the court may approach future executive power cases. Looking ahead, several major disputes are expected to reach final decisions, potentially by mid-2026. These include litigation over birthright citizenship, policy changes, the scope of presidential tariff authority under trade statutes, and the removal protections of officials serving in independent agencies such as the Federal Reserve and the FTC. Legal scholars caution that predicting outcomes remains speculative. While some analysts anticipate the court may limit executive authority in certain areas, others argue the justices could issue narrower, case-specific rulings rather than sweeping constitutional judgments. Much will depend on statutory interpretation, precedent, and constitutional framing within each case. If rulings do set new boundaries, they could shape how future administrations, regardless of party, interact with independent regulators, trade policy tools, and immigration frameworks. Conversely, decisions affirming broader executive discretion could expand presidential influence over regulatory and economic policy. For now, these cases collectively represent an ongoing constitutional conversation about executive power, congressional authority, and institutional independence. Final decisions have not yet been issued, and their legal